Hi, my name is Lisa Damon. I'm a partner at Cypher Shaw, and today I'm speaking with my good friend and partner, Lynn Kappelman. Lynn is an L&E partner at Cypher who has many years of experience focusing on litigation, trials, class action discrimination cases, non-competition, and trade secret disputes. As part of her practice, Lynn also has a national reputation and a special focus on religious issues in the workplace. We'll provide Lynn's contact information later in the program. Today, Lynn, we're here talking about the Supreme Court decision in Kennedy versus Bremerton School District that was decided the end of June, and talking a little bit about what kind of impact, if any, that has on employers. So, Lynn, can you first share with us a little bit about the decision itself?
Yeah, Lisa, it was fascinating. There was a fellow named Joseph Kennedy who was a high school football coach, and it was his practice to kneel at midfield after every football game and pray. And there are a few facts you need to know about that. He was kneeling by himself, but it was a very public display and a public expression. And so the Bremerton School District said, we need you not to be so obvious in your prayer. We're worried that by publicly allowing you to pray, it looks like the school district, a government entity, is endorsing you and your activity and endorsing your religion. And they said that they thought that they were violating the constitutional establishment clause. Joseph Kennedy got up in arms and he sued the Bremerton School District after they told him he couldn't pray anymore at the 50-yard line. And he said that they were violating his First Amendment rights to free expression and free speech. And that's important to keep in mind, that it was based on the First Amendment rights to free speech and free expression, because that is something that applies only to a public employer and a public entity. So the district court, Federal District Court, agreed with the Bremerton School District and said, absolutely, you would be endorsing his religion, and it also would be coercive to students and other folks if you allowed him to continue to pray. The Ninth Circuit also upheld the district court's decision, and they ruled that the school district shouldn't be perceived as endorsing his ruling. But on June 27th, 2022, the Supreme Court of the United States issued a decision in this case, and believe it or not, made a seismic shift and sided with the high school football coach in his First Amendment case and said he should be permitted to pray at the 50-yard line. And in so doing, they basically upended the existing balance between First Amendment rights to free speech and free expression and the Establishment Clause. And so it's a really interesting case from that perspective. What I wanted to do was read both the Ninth Circuit's, a piece from the Ninth Circuit's decision, Lisa, because I think it's instructive for the rest of our discussion. Ninth Circuit said Kennedy's on-field religious activity, coupled with his pugilistic efforts to generate publicity to gain approval for his religious activities, could lead someone to conclude that the Bremerton School District endorsed his activity and violated the Establishment Clause. And on the contrary, the Supreme Court said, quote, when Mr. Kennedy uttered the three prayers that resulted in his suspension, he was not engaged in speech within the scope of his duties as a coach. He did not speak pursuant to government policy, and he was not seeking to convey a government message. And therefore, he should be allowed to engage in his free speech and free expression. And that's really some important language from the Supreme Court when we construe it going forward.
Yeah, fascinating. So Lynn, does the Supreme Court decision change the way private employers need to respond to employees who wish to express their religious view publicly at work?
It's a great question, Lisa, because that was my first question. And then I realized that the First Amendment doesn't apply to private employers, right? It applies to government entities and public employers. So it really doesn't create any new rules for private employers. And private employers should be continued to be guided by Title VII of the Civil Rights Act of 1964. And you know that is the statute that talks about religious accommodation and religious discrimination, among other things. And what it says is an employer has to reasonably accommodate an employee whose sincerely held religious belief, practice, or observance conflicts with a work requirement, unless doing so would pose an undue hardship. And of course, there are specific rules about the undue hardship defense in a religious accommodation case.
Great. Lynn, how about private employers? Can they discourage religious displays in the workplace? What are the rules around that?
Absolutely. And here's what I'll say. Under Title VII, it is a real balancing act, and it always has been. Because under Title VII, you have to balance the religious individual's rights with everyone else's rights not to be offended or disrupted or discriminated against. And so if an employee's religious expression was offensive to others or disruptive in the workplace before this Kennedy decision, it's still not okay. An employer can still discourage it. But let me give you some examples because I think this can be a little confusing. I mean, look, you have to try to accommodate an employee's request for religious expression. But if somebody has a cross at their own desk, for example, probably not offensive or disruptive to others, depending on where they sit or where the cross is. But if an employee wants to erect a big creche of the baby Jesus in the office where everyone sees it and walks by it, or displays a sign that says God hates homosexuals, that obviously is going to be offensive or disruptive to other employees who have protected rights in the workplace. And a private employer still does not need to permit that kind of religious speech or expression.
Great. Does the change then, Lynn, from the Supreme Court, does it impact Title VII of the Civil Rights Act that requires private employers to accommodate an employee's religious belief unless it can create an undue hardship?
So far, no. And I say so far because it wouldn't shock me if this activist court was reviewing a Title VII case on religious accommodation and rewrote decades of religious accommodation law and religious discrimination law. Having said that, this Kennedy case doesn't do that. It really is about public speech and public employers. And so we still have the same undue hardship test for employers when looking at religious accommodation issues. And please remember that the undue hardship test for religious accommodation is really that the employer must prove, in order to avoid accommodating, must prove that it would be an undue hardship to accommodate the employee's religious expression. And that is only a de minimis hardship. It is not a significant hardship like we see in the disability cases. It is a de minimis hardship under Title VII.
So, Lynn, let's just do as we close one very specific example. Can private employers prohibit a manager from opening her staff meetings with a prayer?
Absolutely. I mean, as we said, this decision was about a public employer, a school district, and it doesn't apply to private employers. And so there's no question that a manager cannot open meetings with his or her own particular religious prayer, because that would be seen as offensive, disruptive, or discriminatory to others. But I would even go further. I think here, SCOTUS found very persuasive that Kennedy was praying alone in midfield on the football games, and that his prayers were not coercive on the students or others. So I would even go further and say that I still think government and public employers wouldn't have to permit a manager to open meetings with a prayer, because that could be seen as part of the manager's duties and coercive on others.
Lynn, that was incredibly helpful. Thanks so much for breaking down the ramifications of the decision. Like most things, change is inevitable, but now this is what we know for now. Lynn, thanks so much for your time.
My pleasure, Lisa. Thank you.